Welcome to the Weekend Brief with Bharat.law for the week starting May 11th, 2026. This week we are covering a diverse array of civil, criminal, and administrative disputes. Our first update is from the case of Vakir Mahmud Suleiman Sameza versus Adani Ports. The Supreme Court answered a critical question regarding court procedures. Is an oral order dictated in an open court final? The court ruled that an oral dictation is merely a draft. A judgment becomes final and binding only after the judge signs and uploads it. The court also clarified that judges are allowed to make minor corrections or refinements to the draft in their chambers without needing to rehear the case, as long as the court decision does not change. Next, we look at Recount Ojha versus State of UP, a case dealing with multi-state land fraud. Two factions were fighting over the management of a spiritual society, and one group allegedly used forged documents to illegally sell the society's properties. The High Court had paused the filing of a police charge sheet, treating it simply as a civil management dispute. However, the Supreme Court firmly cancelled this stay. The court ruled that a pending civil dispute cannot be used as a shield to block criminal investigations into organized forgery and cheating. To ensure a fair probe, the court formed a special investigation team to investigate the fraudulent land sales across all jurisdictions. In a land acquisition matter, the project director NHAI versus Alpha Remedies, involving compensation for land acquired for a national highway. The landowner claimed the land was industrial, and an arbitrator used the high price of a single residential land sale to calculate compensation. The Supreme Court struck down this award. The court stated that under the Land Acquisition Act of 2013, you cannot use an isolated sale of residential land to determine the value of industrial land. Instead, the authorities must apply the statutory ready reckoner rates to ensure uniform and fair compensation. Turning to matrimonial and family matters, in the case of SAURABH DUTT versus SAURABH IQBAL BAHADUR DUTT, the Supreme Court held that a wife's decision to pursue her career and reside separately for her child's welfare does not amount to cruelty or desertion under the Hindu Marriage Act. The court strongly rejected patriarchal norms that expect a wife to sacrifice her career for her husband's postings. The judges called such expectations regressive and against modern constitutional values of dignity and equality. On property and inheritance, the court reaffirmed a daughter's right to property. In B.S. Lalita versus Bhuvnesh, the court stated that daughters have an independent right to inherit their father's share as Class 1 heirs upon his death without a will. The court clarified that Section 6(5) of the Hindu Succession Act is not a bar to filing a partition suit, ensuring daughters are protected against secret or fraudulent family partitions. Next, an important clarification on the SCST Prevention of Atrocities Act. In Gunjan alias Girija Kumari versus State, the court ruled that caste-based abuses hurled inside a private home do not constitute an offence under the Act, unless members of the public were present or could have witnessed the act. Emphasizing that the offence must occur in a place within public view, the court quashed the criminal case, noting it was part of an internal family property dispute. Moving to motor accident claims, there is excellent news for those with private health insurance. In the New India Assurance Company Limited versus Dolly Satish Gandhi, the Supreme Court resolved a conflict among high courts regarding medical reimbursements. It declared that if an accident victim receives medical reimbursement from a private medical policy, that amount cannot be deducted from the statutory compensation awarded by the Motor Accidents Claims Tribunal. The court clarified that private insurance benefits are a result of paid premiums and do not cancel out the right to just compensation under the Motor Vehicles Act. Healthcare billing disputes were also addressed this week. In Narayana Health versus State of West Bengal, a patient's family filed criminal charges of cheating and criminal breach of trust over a 2,500 rupees unperformed test billed by the hospital, even though the hospital admitted the error and offered a refund. The Supreme Court quashed the criminal case. The court ruled that routine billing discrepancies are civil or statutory disputes, and criminal law cannot be weaponized without clear evidence of dishonest intent. In the education sector, the court delivered a significant judgment regarding the right to learn in one's mother tongue. In Padam Mehta versus State of Rajasthan, the court directed the Rajasthan government to formulate a policy to use the Rajasthani language as a medium of instruction in schools. The state had argued that Rajasthani is not recognized in the 8th schedule of the Constitution. However, the court held that the right to receive education in the mother tongue is protected under Article 19, 1, officio A, and Article 21A, ordering its progressive implementation. In a move protecting investors, the court expanded the scope of state depositor protection laws. In Alka Agrawal versus State of Maharashtra, investors had advanced 2.51 crore rupees to individuals for a resort project, expecting high quarterly interest. When the money was not returned, lower courts dismissed criminal cases, calling it a mere civil loan dispute. However, the Supreme Court ruled that these private individuals qualify as a financial establishment, and the money is a deposit under the Maharashtra Protection of Interest of Depositors Act. This allows investors to seek strict remedies even if the transaction was casually labeled a friendly loan. This week, the court delivered two major decisions on how evidence is evaluated in murder trials. In Mitesh Waghela versus State of Gujarat, the Supreme Court upheld a murder conviction based purely on the dying declaration of the victim and the testimony of a single eyewitness, a rickshaw driver. Even though many other witnesses turned hostile during the trial, the court stated that the quality of the evidence matters more than the quantity of witnesses. A truthful dying declaration and one reliable eyewitness are completely legally sufficient for a conviction. On the other hand, in Tellari Naresh versus State of Telangana, the court acquitted a man sentenced for murder under the SC/ST Prevention of Atrocities Act. The prosecution's case relied on interested and hostile witnesses whose statements heavily contradicted each other. There were also major unexplained mistakes in the medical post-mortem reports. The Supreme Court emphasized that even under protective laws like the SC/ST Act, the fundamental rule of proving a case beyond reasonable doubt cannot be ignored. In Rohit Chaturvedi versus State of Uttarakhand, the Ministry of Home Affairs rejected the premature release of a life convict who had served 22 years with good conduct, even though a co-accused had already been released. The Supreme Court quashed the rejection, noting it was an arbitrary order without any reasons. The court emphasized the reformative theory of justice, stating that remission must be based on a prisoner's reformation and current conduct, not just the gravity of the original crime, and equality must be maintained among co-accused persons. Moving to corporate law, the Angelwoods Apartment Allottees Association case brings a strict warning for anyone filing appeals under the Insolvency and Bankruptcy Code. In this case, an appeal was filed at the NCLAT on the very last day of the deadline, but without attaching a certified copy of the original order. The Supreme Court ruled that filing an appeal without this certified copy and without officially asking for an exemption, makes the appeal legally incompetent and non-existent. The court declared that tribunals cannot forgive filing delays for appeals that are fundamentally defective. Finally, in a major relief for the energy sector, the court decided State of UP versus Reliance Industries Limited. Reliance sold natural gas from Andhra Pradesh to buyers in Uttar Pradesh, transporting it through a common pipeline. The UP government tried to charge local value added tax, arguing the sale was completed when the gas reached their state. The Supreme Court rejected this argument. The court held that because the contract caused the movement of goods across state borders, it is an interstate sale governed exclusively by the Central Sales Tax Act. Mixing the gas in a common pipeline does not turn it into a local sale, meaning the state of UP has no power to tax these transactions. That wraps up the key updates from the Supreme Court for this week. Log on to bharat.law for updated research, document intelligence, court notifications, and elevate your legal practice with trusted AI. Until next week, this is Nyay, your trusted AI on bharat.law.